Mr. Justice Vikas Suri and Honorable Mrs. Justice Alka Sarin, who have very graciously accepted our humble invite and have taken out time to speak today for this event. We also welcome Shri M.L. Sarin, Senior Advocate Sir, and Mr. Animesh Sharma, who has very kindly consented to be the panelist speakers for this evening. Today on the 10th of February, while we pay homage to Senior Advocate late Shri H.L. Sarin on his death anniversary, we will discuss a topic that is very close to his heart, that is the art of advocacy. From having his practice at Lahore to later shifting it to Shimla and then at last setting it up at Chandigarh, Sarin sir's life and his dedication to the legal field continues to inspire us in our journey in this profession. On the tables, you will find a brief document with pictures about his illustrious life and legacy my colleague Gulsher has prepared. To discuss this topic, we will have serial wise Mr. Animesh Sharma, who will be going first, followed by Honorable Mr. Justice Vikas Suri, thereafter Honorable Mr. Justice Anupendra Singh Garawal and Honorable Mrs. Justice Alka Sarin, and at the end we will have Shri M.L. Sarin, Senior Advocate. We have specially requested him to speak at the end so that, being the senior most amongst us, he can sum it up perfectly well for us in case of any default and he can cover it up. I am Advocate Gurneet Saggu and I shall be moderating this session. I will be requesting each speaker to give their views and we will have an interactive session at the end. It is an honor to be asked to address this august gathering. The aim of this lecture is to augment and contribute to the legal education, legal research and training for the members of the bar. On a bird's eye view, this topic may come off as very simple, but as you dwell deeper into it, one can realize that it is very vital to understand the science and evolve around the art of truly being a great advocate. Without further ado, we now have Mr. Animesh Sharma, a rising star of our bar. Mr. Sharma has passed out from NLU Bangalore and has joined the practice thereafter. He has now completed 17 years of practice. So over to you, sir.
Thank you, Gurneet. I must thank you first, and I must thank the Bar Council for asking me to be a part of this group. I feel both honored and awed to be a part of this august gathering, and privileged to be a part of this group. I have worked with Mr. Sarin on several matters, and I will be talking about research and drafting skills. And I must tell you, when I worked with Mr. Sarin, when you go to his office, you come across a pencil which is not commonly available. It's a pencil that is red on one side and blue on the other side. And I've learned from him that anything that is underlined in red is against you, and anything that is underlined in blue is for you. So when you're reading your brief eventually, or a judgment, you can exactly pinpoint as to what is in your favor and what is against you. I've worked with him and I've seen his registers, which have judgments that go back to several years, and he knows his page numbers and he knows where to look at in what register, and you can immediately find what you're looking for. And that is an art, I think, of research, which possibly because of the online age that we are in is dying out. I don't think we make registers. I will today speak about the research and drafting skills that I have learned over the last few years as a youngster, the tips that have helped me in researching and drafting, and perhaps those tips can help people here, people who are starting off, youngsters who've just joined the profession. So when you start your research, these are just some pointers. I've also left a document which can possibly help everybody. But when you start your research, I think the first thing that one should do is to look at the Parent Act first. Not just the section that you're looking at, but also the Act, read around the section that you're looking at, read the sections and the provisions around the particular section that is in question, so that you can get an overview of the law. Start with the Act first. Often we don't start with the CRPC or the IPC or even the Constitution. We look at the issue in question and we don't look at the general laws. It always helps me to go and look at the law. And whenever I meet a client, I feel it is okay for me to tell a client, I will get back to you on this point. If I don't understand that point, let me do a preliminary research and then I'll get back to you. And then reading the Bare Act always helps me. We are also in this world today of legal softwares. For good or bad, this is how our research is now inclined to be. We will all first go to the softwares. So I think we all need to be well versed with our softwares. But the key to be well versed with our softwares, I think, is to know your keywords first. Because if you generalize your research and search for that general word in your software, you're possibly not going to find it. So one skill of researching legal software is to be able to narrow down on your keywords. And to do that, you have to be able to summarize that issue in your head. Get to those keywords. One way to understand keywords, one way to understand legal language is to perhaps pick up a seminal judgment or a latest judgment on the issue in question. Judgments these days are reproductions of various previous judgments. So if you pick up a seminal judgment or a latest judgment, it will give you an overview of the entire gamut of law. And that possibly can then help you research, narrow down on your research, help you with the keywords that you're looking for. And when you're researching judgments, I think all courts will also say that research the law against you as minutely, if not more minutely, than the law that is in your favor. And also never hide the correct position of law. I think you will always, or in most occasions, be able to distinguish the position of law. Try to do that, but do not hide the correct position of law in any court whenever you are arguing. As a rule, I have never done that. I think it's a good practice to follow. Keep abreast of the law. These days, websites like Live Law, like Bar and Bench are great to being updated on the law. You can subscribe to the website, you can subscribe to their emails, to their WhatsApp groups. As a practice, one thing that I do, and people who can do it, is to read the SEC online on a weekly basis. Again, that will perhaps help you in understanding legal language, in understanding the important issues at hand, and will keep you abreast of the law. So that again will help you with your research, that again will help you with narrow down on your keywords. If you know what is the question, what is the latest law on a subject, that will help you presenting that law as well. Another very important thing, I think, as a youngster, we've all encountered in courts, is to not just rely on head notes, because head notes can often be misleading. So when you're reading a judgment, please just don't rely on the head note. Also go to the relevant paragraph. Also understand the facts of the matter so that you can explain the context of the judgment that you are relying upon or quoting in court. And head notes will often be incorrect, because head notes are prepared by the organization or the person who is creating that judgment. It is not a part of the judgment. So please read the head notes, but also read the text of the judgment. Today, I think another important aspect is to not rely on ChatGPT or AI for your research. I know people who do it, but the problem of hallucination in these software is real. So even if you are relying on these softwares, possibly cross-check what results they come. Because these softwares are great at summarizing, but in law what you're looking for is precision, and you cannot be wrong on law. And so therefore don't solely rely on these softwares, always cross-check. Now coming to, this is how you will possibly start your research. The second question is, what I have narrowed down is how to present your research. So the first thing that is very important as a lawyer when you go to your court is to keep your eyes and ears open in any court that you go to. Because often during the course of arguments as well, you'll hear judgments, you'll hear arguments that you can use in your favor in that matter of yours, because rosters will often be dealing with similar subjects. And also for future references, you will get to know laws, judgments, important arguments that are coming up often in courts. So keep your eyes and ears open. We are all guilty of spending our times on our phones when we are in court. So possibly keep your eyes and ears as open as possible. That will help. It is also important to research the kind of argument that you must lead in the court you are in front of. So essentially reading the court. There are courts where you must start with your star argument first up, with hitting the nail on the head. And that is what works in that court. But there will also be courts where you must build your argument. You must first come to the facts of the matter. You must first explain how that situation came about and then come to your argument. So as a lawyer, as a young lawyer, one skill that possibly everyone needs to assimilate is to be able to research and read the court. And so therefore, another thing you can do is read the judgments of that particular bench, research the trend of cases that has followed in that particular court. That will help you frame your argument in that court. And so frame your argument in the way that that particular court is likely to hear it in your favor. So read the bench. Always have a compendium of your judgments with index, page numbers and relevant paragraphs marked. Possibly a brief note on the facts as well. Your compendium should be ready in all your cases, and collate these compendiums, because often these compendiums will be used, especially the ones that are on major issues, can be used and reused again. So you can collate them online, you can collate them as hard copies, but keep that set ready. Another thing that always helps me is that preparing a brief note, a written submission on your case and passing it on shows to the court that you are well prepared in your matter. So it also shows that you have taken the effort of preparing a note, and it also stands out because not often during court arguments do lawyers present written notes first up. Unless people are asked for notes, people don't present notes. So preparing a note certainly helps. It will also help you possibly get your case decided faster, because one job as a lawyer for us is to be able to simplify the matter so that a court can decide it. If it's complicated, it's possibly going to get adjourned. So simplifying is our job, and that note can help you do that. And the best time to prepare that note, I feel, is when you are drafting, because at that point of time the facts are fresh in your mind. You can prepare your note, you can page number it later, but prepare that note, present that note. I think that note helps. So these are my pointers, some of my pointers on research. As far as drafting is concerned, now again, a good draft will often mean that you don't need to utter a word in court. On the first date, if your draft is good, in some courts you'll stand up and say please, and notice will be issued because your draft is that good. So drafting is essential, it's crucial. I also feel a draft should not only be just thorough, but it must also look readable, it must also look presentable. So if a draft has paragraphs which are running through whole pages, I don't think it's readable. I would not want to read that draft. So please be conscious of the look of your draft. Please be conscious of the draft must not only be readable, it also must look readable. So it must be inviting, and that is not hard to do. We can all possibly work on that. We can all possibly keep our paragraphs shorter, concise. So in this light only, we can use bold, italics to highlight the points that we are looking at, to take attention to where you want to draw in your draft. Another point is that while drafting has to be comprehensive, I feel comprehensive does not mean repetitive. Often we repeat arguments, so when we are drafting, we should not leave anything out, but we should also not repeat anything because we want our draft to just look big. Another very important point of drafting, especially in writ petitions, I feel is that the head note is crucial, because if you are able to frame your head note well, if your head note is precise and it can sum up the problem well, often you frame the issue in your head very well, and then you understand your problem well. And so keep special importance for your head note. When you are drafting, ideally your facts should possibly flow in a timeline, sequential timeline narrative. So the facts will flow from starting to finish. It's easier to read them, and never fail to disclose essential facts. Even if they tilt against you, even if they are partly against you, don't not disclose them. You can always explain them, but if you don't disclose them in your draft and then they later come out, that will go against you much more than if you have disclosed them and then explained them. I think another very important point which a lot of us are guilty of is that while we do our own drafts, our synopsises and our list of dates and events are left to stenos. Often, I feel, again, to simplify a matter, if you are mindful of your synopsis, if you are mindful of your list and dates and events, it is possible that a court which is already overburdened will possibly read your synopsis first and then read your other draft. And so if your synopsis is good enough, maybe you don't need to emphasize too much on your draft later. So be mindful of your synopsis, be mindful of your dates and events. Identify your star argument and focus on that star argument in your draft. That star argument should stand out. As I said, sometimes in a court, your star argument will be enough to get you relief. So identify the star argument and focus. Your draft should be should be able to focus on the star argument. Another very important thing is to be able to sift through the documents that you want to annex in your draft and narrow down on the relevant documents. Because again, I emphasize, a bulky petition is a petition that possibly will be harder to get decided. So it is not that you should not have all essential documents, but some unessential documents or documents which are not necessary, if you can avoid them and if you can keep your petition as readable and as approachable as possible, you will possibly be able to get it decided sooner. I'm concluding here, but be mindful of your prayer. Do not leave out important prayers. Be mindful of your questions of law. When they are drafted well, it again reveals that you've worked on your draft. If you're able to frame them well in your head, you have possibly understood the problem well, and then you will be able to deal with it. Another thing which possibly I have been guilty of, others have been guilty of, is that be mindful of your translations, especially the translation that you're relying upon, especially the document that you wish to point out in court. Because if translations are wrong there and you are apologetic about that, you possibly will lose the court and you will not be able to come across in the proper manner. So be mindful of your translations. And so as I said, a good draft is often good enough to get you your relief. Be conscious of your drafting. These are some tips that have helped me over the years. Possibly if I can share this knowledge and somebody else can use these tips, I'll be very happy and we'll be able to get better dispensation of justice. Thank you.
That was quite helpful and insightful. Next we have Honorable Mr. Justice Vikas Suri, who will be sharing his thoughts with us. Justice Suri is known by his kind heart, benevolence and his dynamic personality. His Lordship belongs to a family of renowned lawyers and publishers of law journals. His Lordship enrolled as an advocate in August 1992 and was later promptly admitted to the bar. His Lordship initiated his law practice under the tutelage of senior advocates Shri H.L. Sarin and M.L. Sarin, and practiced in various fields of law before joining and being sworn as the additional judge of our Honorable High Court in the year 2021. So over to your Lordship.
Thank you, Guni. Animesh has articulated a lot more thoughts. Even I had thought about presenting something. When we talk about art of advocacy, we only know about the instances we see in court and see that how brilliantly a lawyer has responded or thought on his legs and responded to a query or reacted to a retort either by the other side or by the court and handled it so well. But what goes behind to reach that stage is very important, and like Animesh rightly emphasized upon preparation, I would also like to share something about what goes on behind the scenes. And I would like to start from the initial stage when the client first interacts with you. It is very important to first hear out the client at length, because the any law which is to be applied must be applied on facts, and any deviation in a fact, anything omitted or misrepresented can change the outcome of your case, because the same law would be applied a little differently. So it's very important to understand the whole case from the litigant. Now, because the aggrieved party would always have everything jumbled up, would give you in bundles or would give you in packets. So it is for you to sit down and patiently after hearing the litigant, take down copious factual notes, then rearrange them chronologically so that you're able to build his factual position or the background as it would have appeared over the years as narrated. In the end, you should have mastered your facts so well that you ought to know the case better than the client on facts as well. Then after you've done this, next comes is the drafting part, which I would not delve much into. Animesh has covered, but I would now out of experience also would add that brevity is the soul of wit. So the briefer is your brief or your presentation, you are more likely to have your point put across sooner. A lengthier paragraph can be confusing both to the person who's drafting it and to the reader as well. And then in the end, when you have to comprehend everything, there would be where you might have contradicted in the earlier part of the para or the second part. And if you go back to the provisions of CPC, that also provides that pleadings have to be very brief. They are not ought to be argumentative. As we see today, there are judgments being appended as annexures, they are being quoted in between. So one can always have a factual summary and then maybe a legal summary in your grounds where you assail it. So that if you keep that in mind, it would always help. Not making it sound more of a lecture, I would like to share some instances which I very fondly remember. Is my first day in office as an excited young budding lawyer, not budding I would say, but excited young lawyer when I entered the office after getting my license, though I'd been into the office earlier also as a child, but I was very happy and I was asking what to do. So there were a whole lot of briefs for the following day which were on the table of Mr. Harbans Lal Sarin ji, and he said, read anything, whatever you're comfortable with. And he gave me a few indications, a few revisions, one matrimonial matter, and in the first evening, whatever little I could, I did it. So very happy to be on time on the next day, trailing him court to court. We went about. So majority of the motion matters were done by lunchtime, and when we broke for lunch hour, so my wanting to get my further instructions, so I said, okay, we can reassemble at 2:15. I was very happy, but I was looking at the list, which all matters are left. They said, no, it's something very important. I'll tell you after lunch. And after lunch when I came, he took me to being a senior advocate, though he had a whole battery of lawyers going there and very competent office assistants who used to help with the inspection. He personally took me to the inspection branch. And he told me the importance of that. It is so important that the file which the judge holds, you ought to have a replica of that file, page for page, word for word. So whenever a judge turns a few pages, if you are taking the judge through something, and the judge turns a few pages, and you also turn your pages, and you know where the judge is reading. So you're able to anticipate what kind of question is to come to you. So it gives you a little head-on, a thinking time. Plus, those were the days when the pleadings used to be manually typed. They were on a manual typewritten format. And lawyers used to carry out corrections by hand, which at times got missed out on the copies given to the other side. So when you inspected that, you could also have those corrections with you, and that always helped you quite a bit to whatever you missed out. Apart from having the pagination and the interim orders, now those things may not be relevant in today's date when you have your interim orders online, you have your digital copies of the entire pleadings, paper books available through the lawyer's digital diary. But the importance of inspection of being updated of the court record cannot be undermined. So that would be one aspect which goes a long way in preparation. The other thing which comes a little with experience, your involvement, your reading and your dedication, is always be updated with the statutory law changes as well as the recent case laws. I would not delve much into it, animation is already covered. There are so many options available, so many platforms. All what you have to do is keep reading, remain involved. But one very important aspect which I learned from the Sarin offices, whenever you come across something, always make sure to make a small note of it somewhere. And over the years, you'll realize that these small notes which you make turns into your arsenal for law. It will have judgments and it will have all the latest changes and everything there. And one of the documents being shared, everyone, I think so, I would have been through this copy and would see that at the end, the way Mr. Sarin used to make his notes would have 3 aspects covered in it. Would be a factual note, where to find it, what page, what line, any changes in law, and any relevant case law for that aspect. So at a glance, once you have prepared the matter, no matter if it came up even after 16 years, one glance at it and then you are ready to go for it, because you've already spent so much of time into that case and you know each and every aspect of it and you can go into depth. So keeping those notes is very essential, and that would also help you in correlating once judgments are overruled. There used to be one journal by the name of Index to Case Law. I don't know if anyone is familiar with that here, but for Mr. Sarin. Mr. Sarin and my sister Alka Sarin, that was by Mr. Goswami. That used to happen when now we have these softwares to show you in the red, overruled, dissented. So earlier this manual used to be, Index to Case Law was with AIR. So with the AIR citation, if you went to the relevant citation, you knew where it has been followed, where it has been overruled, dissented, or distinguished, or clarified. And that one advantage you get when you are making your own notes. I have a lot more fond memories of the office, but relevant for the art of advocacy. What then comes is your articulation. Articulation is not a diction in court. It is how well have you understood the case, how well have you presented it, and simplicity is the essence. If the most complicated case you are able to simplify, say a 500-page paper book, you are able to simplify and give it, explain to the judge in say about good 5 minutes, or in a synopsis of 2 pages, you've already made your mark. And that is again brevity in pleadings, clarity of thought, both factual and legal, and you summarize it and you'll be able to do a wonderful job. And that over the years, each one has his own innate skill which develops and shines, and that what makes one different than the other and one better than the other. With that note, I'll
That was again very interesting and insightful. Now we have Honorable Mrs. Justice Alka Sarin, who will be the speaker for this segment. Honorable Mrs. Alka Sarin's personality and her aura is known by all of us. Anybody can walk up to your Lordship's courtroom and learn a great deal about civil law at any point of time. Before being elevated to judgeship, Honorable Mrs. Alka Sarin, your Lordships, was a budding advocate, and she had practiced at the Honorable Supreme Court of India, Delhi High Court, as well as our very own bar. And over to you, your Lordships.
Thank you. This is really sweet of you. Thank you. So this is very personal to me. Mr. H.L. Sarin, my grandfather-in-law, Nanaji, as I addressed him, was very, very special to me. I got married in 1991 March. I came to Chandigarh. From the station, as I was entering the Sector 4 house, he did not let me get into the house, but ushered me into the office. He said, "Nahi beta, first you must come and see the office." So I walked into the office, and there were all these file covers, wakalatnamas with my name on it. He said, "Dekho beta, aapka maine naam likhwa diya." So I told him, I said, "Nana ji, but I have not changed my name yet." He said, "Beta, wo bhi ho jayega, doesn't matter, but everything is all set. Now you have to tell me when you're joining." So I said, "All right, give me a few days, I'll join." By 1st of April, I got married in March, beginning of March, and 1st of April, I had joined my work. So what I learned from Nanaji was that he said that when you enter into court, please know what your file is all about. Read your papers. Don't enter into the courtroom without reading your file, and definitely not without your file. So here, in cases like FAOs and all, these are simple matters. And if your senior is not able to attend court, when you're coming to court, say a simple matter for enhancement, please read your file. If you are able to assist the bench, even for, with those couple of facts, your case will be decided. You will get an opportunity to argue. So encash on that opportunity. What is happening today is that in a lot of cases, what is coming to fore is that a lot of lawyers coming saying that I've just been instructed by my senior. They don't have the file. They don't know what is in the file. Please don't do that. That does not leave a very good impression. And if you are prepared with your matter, the judge will help you. You will actually be able to argue the matter and maybe even win it. So please take that opportunity to argue your matter. When I've been now in the civil roster for such a long time, so what do I look for when, say, somebody is coming to address an RSA, address arguments in an RSA? By the time you come to the High Court, very few points left. Say maybe just the question of will is left. Because of paucity of time, those were earlier times when you would read the trial court judgment, you would read the appellate court judgment in court, and then, you would address arguments. We don't have that kind of time. You've seen the pendency, you've seen the kind of pressures we all work under. So what are we looking for is for you to give me those few facts and then address your arguments on the point. You make your point, notice of motion, stay, everything is granted. But that is what we are all looking for now, is that briefly state your point, make your argument, show whatever judgments you want, so that we are also able to pass orders very quickly in the matter. You don't want delay in your matter, we don't want to delay your matters. So if the lawyers are assisting the bench will be able to actually dispose of much more. So what we are actually now, this pendency has to be addressed by all of us, the lawyers as well as the judges. And how can we do it is by joining hands and helping each other. If we get the help that we require, we will also be able to deliver the judgments and to dispose of these matters. One thing which I want to share with all of you, which I learned from Nanaji, was that Nanaji was 80 plus when he passed away. And he passed away in February. Until December, he was coming to court. Nanaji never ever asked his clerk to pick up his file. Wherever he had to go, our files used to be kept outside courtroom number 4. He never hesitated, he never felt shy, he never felt ashamed for doing things on his own. He would pick up the file and he would run to the court. And we'd be trailing behind him saying, "Nanaji, no, give us the file." He said, "No, beta, this file I have to have, because in case I reach court, you don't reach court, how will I address arguments?" So please, so what are these? These are just little tips that we learned from Nanaji, from Mr. H.L. Sarin, as to what is important when you're going to court as a lawyer. And it will take you a long way. Another thing which he always emphasized was that when you're free, you're waiting for a case, don't wait outside. Sit inside the courtroom, you will always learn something. And believe me, please, I really, really learnt a lot. So, we'd have these Wednesdays when we would have all old cases. While waiting, you heard the arguments of lawyers, you heard the observations of the bench, you also saw the mindset of the bench, you learnt a lot. So if you're sitting in court, you will always pick up something, you will always learn something. So these are some of my thoughts shared with you.
Thank you, Your Lordships. Again, it was very helpful and insightful for all of us here. Now we have Honorable Mr. Justice Anupinder Singh Garewal. His Lordship's aura and his charm is hard to miss. His Lordship's started his practice in the year 1992 at our bar. Later on, he was appointed as the Assistant Advocate General, thereafter joining as the DAG and Senior DAG. His Lordship is also a first generation lawyer. So over to you, Your Lordships.
It's a wonderful initiative by the Bar Council to organize such sessions which help the young lawyers. In fact, I was in a division bench a few years back. The presiding judge was from Maharashtra. He had mentioned that the Maharashtra Bar Council organizes training sessions, training programs for young lawyers. So it's a wonderful initiative. I hope you keep up the job, and we will be here to address on various topics. The topic, of course, today, we are here in memory of Mr. H.L. Sarin. He was, as you all know, the doyen of the High Court Bar and a master of civil law. Any problem relating to land, rent, or civil dispute, he was the first point of contact. In fact, my father used to go to him and he was representing him. We faced 3 land acquisitions. That's one of the reasons why I am a lawyer. So, and Mr. Sarin, H.L. Sarin was such a pleasant personality, and he would never hesitate to help any young man. He was full of calm and composure. We rarely saw him losing his temper or raising his voice. So he was a role model for us. And then, of course, is a great initiative. Mr. Sarin, M.L. Sarin is carrying forward the legacy, followed by Justice Alka Sarin. And in fact, we were just calculating, there are several members of the judiciary who have been working in the chamber of Mr. H.L. Sarin. Justice Jayashri Thakur, Justice Ritu Bari, Justice Suvir Sehgal, Justice Alka Sarin, Justice Aman Chaudhary, Justice Vikas Suri, and Justice Bedi. So all of them, it's a big achievement, having about 7 members of the judiciary passing out or coming out of the chambers of Mr. Sarin. So, and the rest, of course, Mr. M.L. Sarin will be addressing on various aspects. As rightly said, I am the first generation, not only the first generation, first person from my family. I didn't even have any distant or any country cousins also in law, neither any of the uncles. So that was it. When I got my degree from Delhi, so I was intending to start practicing in Delhi. I was going to work with a law firm. My parents wanted me here. Moment I came here, the first question everybody was asking, is there anybody in your family who's into law? I said, nobody. He says, how will you manage? There, Chandigarh is full of lawyers. Every second, third house is a lawyer. So I think quite a few would be first generation lawyers. I think majority of the members here, can you just raise your hand who are first generation lawyers? Majority, overwhelming majority. So that's why it's quite relevant what I'm saying. So don't get discouraged. There will be a lot of people telling you, you will very difficult, this and that. Because if you work hard, there's always room at the top. Initially, when you join, maybe you join as senior. And if you are prepared with the facts, try and assist him. Like they you prepare a synopsis for us in court. You give the gist of the case law also to the senior. Then you will become indispensable. That will also help you in setting up your practice. Now, case law, in fact, when we joined this bench 1992, joined the bar, in the senior office, main task should be to take out the relevant judgments. That time what we would do is go for the digests, 92, 91, 90. So what initially I started from 1950 onwards. Then they told me, no, you start from the latest digests. Because the previous case law would be reflected. And that would take several hours in the evening, and next morning again going to the senior's office to dig out. Now you are very lucky. Everything is available on the click of the button, mouse. And what you have to do is, in fact, Animesh rightly pointed out, there are sites like Live Law Bar and Bench, but maybe you have to pay something for that. Now you are already aware that ILR reporting, we are updated the thousands of judgments of the division benches, and all full benches are available on the High Court website, ILR. And that is free of cost. It doesn't cost anything. Similarly, the Supreme Court judgments are available. So that is available to you, don't have to spend a penny. And as young lawyers, you will have lot of spare time. You will have lot of, they say like the young lawyer is at times, it has to cope up with stress. When he doesn't have any case, then also there is stress. And when he gets a case, then also there is stress. So at that time you have, in fact, whenever you get the case, and just go over the facts as they all told you, you need to know the facts and everything. And then of course be concise, because we have hundreds of cases. We are also insisting on synopsis. When a good synopsis comes, it's very easy for us to dispose of the matter. And when you are come to the court, you should try and grab the opportunity of arguing. We have noticed many times you seek an adjournment, they don't not prepared, and when they are a little bit of preparation, we like to give relief to the young lawyer. Young lawyer is in fact representing the cause of a litigant who is not very well off, who cannot afford Mr. Sarin. So he will be going to a young lawyer. So it is all the more responsibility to prepare the case properly, facts and law, so you match up with Mr. Sarin. That will be part of inclusive justice. So the downtrodden of the weaker sections of society, they are also able to get the best legal aid and legal services. And then most of the topics have been, I will share a few instances. Now the draftings have been, Animesh has very eloquently pointed out how should you draft pleadings. Drafting is fine, it's all there. Now when you argue, you have to argue all the relevant, disclose all the relevant facts. At times we have noticed it is pleaded in the petition, but it is very germane to the issue, might go against the counsel. When he is arguing, he will not disclose that. Moment that is disclosed by the other side, maybe there is a delay or he is already availed alternative remedy, you ought to disclose that even in arguments. So you have to be upfront. Whatever is there, even if it goes against you, you should disclose and then argue how it doesn't affect your case. So that's, and any power of silence is very important. Many times we have read it and we are going to grant relief. The lawyer will not stop. He has to make a point. This reminds us of, there's a place in India, I don't want to name they say you don't travel after sunset at night, because there is chances that you will be beaten up and looted. They say even if you just stop there and you give all your belongings, they will say no, we will beat you up also. We don't want to earn anything free. So this is akin to that. When the judge is ready to give the relief, then at least just draw the line. Another aspect which we just noticed recently, and you have to effectively communicate the status of the case to the litigant. The litigant should know what is the state of the case, what is happening. This happened, the law officers are here who are in my court. This is about the Surface Act, the dispute between the borrower and the creditor. Then the creditor was saying they let him pay this amount and about 15 lakhs, then we will settle it. Earlier he was saying 5 lakhs. Then the lawyer said, okay, I am ready to pay, I have got instructions, 15 lakhs. Then we were a little doubtful. We said, call your client. Just call him whether he is agreeable for that. Earlier he was saying he doesn't have any money. So when the client came, then we asked him, then the lawyer started talking to him. It took 5 minutes for him to convince him that he is ready to shell out. Then he said, I can't pay that amount. So when you are giving instructions or something, at least to the court, what are you disclosing? The mind of the litigant. What is that? In fact, you should explain it to the litigant effectively. What is happening in the case and whether matter has got adjourned. We had, in fact, we had a matter in the district court For 2-3 years, we found out that asking the lawyer, he will give a date. Next date is this much. When we inspected the file, the case had been dismissed in default for 2 years back. So effectively, you have to mention. So I think the rest of the issues, in fact, other aspects also, when you have a lot of spare time, you can do so many things, maybe help the environment and others. And also stress, one emphasis on, like young lawyers are under stress, even senior advocates, we are also under stress. And Chandigarh is a beautiful city. A high court is one of the best high courts in the country. The layout, the greenery around it, make good use of it. And when I was a lawyer, in fact, I worked in the AG office for a long time, I would carry my sports shoes, and on the way back, I would go to the lake and have a walk for about an hour or so. That is very important, physical fitness, because that will help you both mentally and physically. Make use of the good facilities. Thank you very much.
Thank you, Archibs. That was very enriching again. Now over to Shri M.L. Sarin, Senior Advocate, sir, who is also the son of late Shri H.L. Sarin. Mr. Sarin joined the bar in the year 1971, and Mr. Sarin is a notable senior member of our bar. So over to you, sir.
Good evening, my young friends. Before I start, I'd like to fortify one of the arguments given by Justice Anupender Grewal. I had a client who would come up to me because maintenance had been awarded against him, and he wanted me to file an appeal saying this is too much. I said, you're guaranteeing your loss, because the moment I stand up, the judges are going to say, you can afford Mr. Sarin. You say you're cribbing about the maintenance, so I sent him to a junior advocate. This is true. This is advocacy. But today, I want to share with you the art of advocacy through the life of a first-generation lawyer. A first-generation lawyer born on the 1st of February 1910 was my late father, Mr. Harbansilal Sarin. No one in his family had even gone to school before that. They were very big landlords, and they had villages named after my father, one after my grandfather, one after my great-grandfather, all within a range of 30 miles from Lahore. But he decided to join law. And what a fabulous success he made of himself. 61 years he practiced, from December 1932 to the 10th of February 1993. Today is 32 years since we lost him. And I have been very lucky that for 21 of those 61 years, we shared one office and practiced together. There are very few sons who can claim that privilege, and very few fathers also. I am one of the lucky ones. Now what Papaji, that's what how I addressed him, what he used to tell me was, Beta, the art of advocacy is not just in a court. It starts from the moment the client comes to you. So he used to tell me, the moment the client comes, understand the case from him, make your note, because everything is fresh, and additionally, you've just got a fresh fee in your pocket, so you want to work. So he says, make your note. And once your note is done, that will go into your brief and it will show up as and when the case is listed for arguments. Second, he used to say, he says, prepare your case so well. Never enter the court unprepared. Prepare it so well that you know it, as Vikas said, better than the client. And once you know it that well, you will go in. But knowing the case itself is not enough. You must be able to convey the point in your case to the judge. If you cannot communicate with the judge, you're a failure, no matter how hard you worked at home. So you have to prepare your case, know it well, and go into court and communicate it to him. And he says it still doesn't finish there. Communication continues, as Justice Grewal just said. Come back home and tell the client what happened in court today. It's not every day the clients come to the High Court. Write a letter that very day to your client with a copy to the lower court counsel who referred the client to you. These are very important practical pieces of advocacy. He used to say, he says, Beta, when you write a letter in English, वो बेचारे पेटू की समझ आना. He's going to take that letter and go to the lower court lawyer who represented him and ask him what has happened. I said, if the lower court lawyer doesn't know it, then you've lost the case anyway. So he says, the client must know, the lower court lawyer must know. And that practice continues in our office till date. Now, we are going to celebrate his centenary in 2032, but we've completed 92 years since he started the practice, and it is going on. And you look back and you realize, yes, this helps so very much. He says, okay, this is, as far as the client is concerned, the art of advocacy in the court is equally important. He says, of course, you know the etiquette, you have a duty to the court, you have a duty to your client, you have a duty to yourself and a duty to the opponent. So in that duty, remember one thing, don't mislead the judge. The moment you mislead the judge, the expression in our days, in the 70s was, the judges used to say, you are using a base coin, you are using a quota coin. And you get yourself a reputation which spreads like wildfire amongst the bar. So remember, being honest and losing a case is better than being dishonest and winning it, but ruining your reputation in the process, because that dishonesty will be discovered one day or the other. Now this is the one thing. Second, he says, the judge is the one who's going to decide. You can't afford to upset him or her. Never fight for the judge. No matter how upset you are, no matter how difficult you are finding it to convince the judge to your point of view, never ever fight with them. Never. Because it's not you who will get hurt permanently. You will get hurt, you lose the case. But it's your client who will suffer. And he will never forgive you for that. So it's your loss and your loss of your client, which is irreparable and can never come back. Now these points of the arts of advocacy, how did he achieve it? He was an incredible organized person. He started the practice on the 1st of October 32, and you will see in the compilation, don't turn around now, it's in there, his page 1 of the first day of the accounts, on 1st of October 32, he started with a royal sum of 850 rupees. I'll show you, I brought the original register of his. And he's recorded the cost of the chairs, cost of the table he bought, which are still there in our office, and the photographs of the chairs and tables are also in this compilation. And he says, unless you can know accounting, every lawyer must know accounting. So it's thanks to that, when in 1994, Akshay Bhan had come from the National Law School in Bangalore to intern with me, I had got a questionnaire from Dr. Madhavan Menon, was the director of the law school there. Do you have any suggestions? And the two suggestions that made were, number one, that every advocate must know computers. Today it's become irrelevant because all of you do. So at that time, it was not known. So I said everybody must be literate in computers. And number two, everyone must know accounting, because accounting is also as much a part of advocacy as law is. Because maintaining accounts, not violating, committing breach of anything and your taxes, etc., is also very material. This was the second thing he said. He was very meticulous in maintaining his register. Every time he argued a case, and I have this almost 85-year-old register with me, which is, this one starts from 1944. The cases he's argued, the case law is taken out, and his handwriting is like printing. It was absolutely superb. And he has made notes of every conceivable argument in the case. So try it. I don't know how many of you do it, because I know computers have come in, and you all rely on computers. The computers are very good. My younger son, Nitin, joined the profession in 2008, and he was also of the same view, that, Dad, what are you doing maintaining registers? And my computers are much better. I said, okay, let's have a competition. So this is the proposition of law. You go and find your judgments on this proposition, and I'll do mine. And in 9 out of 10 cases, I won. Actually, I won, because this register is so effective. You have done it yourself. You're the computer programmer. You're the computer reader. You've written your own language. You can find it. The computer, the electronic one, the moment you go there, it'll give you 10 or 100 different options. But you'll spend the next 3 hours reading which one is relevant. Here, it takes you straight to the relevant one. What is the question of law and order? So this register maintenance is absolutely superb. Third thing he says, if a client comes to you, don't look at him as a source of revenue, because he has come there with a hope, with a great hope, because the legal profession is a noble profession. You are helping somebody who's in difficulty solve its problem. So money is not your criteria. Build a relationship. Convince him, build his faith in you so that he comes back to you even if you have lost a case. And that has paid such rich dividends. I remember a case from Amritsar. Pyarelal was the client's name. He came here, he gave me, I won't go into the figures, but he gave me a fee. And the court fee to be paid was almost equal to the amount in dispute, added to my fee. So after preparing it, I found there's nothing in the case, it's going to be dismissed. So I called them back. I said, look, Pyarelal, tera ta case abhi dismissed ho jayega. Tu court fee pe bacha, meri fees you वापस la, and go and pay it off and put an end to it. He sent me 30 cases after that. This is the art of advocacy. The art is in building long-term relationships, not just looking at immediate gain. And this you have to do in every sphere of life if you want to be a successful lawyer. His clerk, who joined my father on the 12th of April 1952, is still in the office, 73 years later. He's still there. He's almost, man, you might have known his son. We lost him two years ago. Sahil Sharma was an advocate. He died at the age of 42. So that has upset him mentally a lot. Our servants, they joined when they were in their teens and died in our house. Any person who had come to me, even till today, I have clients who come and say, "Vade Sarin sahab nu bada yaad karne hai. Vade Sarin sahab nu bada yaad karne hai." So what is this? It's only your relationships. It's long-term relationships which keep you going. So every lawyer and every doctor must maintain this, because our objective is not to make money, but the utopian objective is that if a client comes, give him such a device that he never comes back to you again. And if you do it sincerely, he will guarantee. If he doesn't come, he'll bring others. Oh ji, mera na sona sa halka raat tha Sarin sahab ne, tu bhi chal milna. It actually works. These are the, I'm telling you from practical experience how it works. Otherwise, there are lots of books about etiquette and courtcraft, etc. But then there's another aspect of Mr. Sarin I would like to highlight. He was elected to the Bar Council right from 1950 onwards. The Advocates Act came in 1961, and the first elections were held then, and he was elected the first chairman of the Bar Council of Punjab, joined Punjab. And under the law, a license had to be issued to every practicing vakil, pleader, advocate, solicitor, barrister, because all these distinctions were prevalent again. So those licenses were issued to a few thousand people in joint Punjab, which was Punjab, Haryana, Himachal, and Chandigarh virtually was non-existent. So he issued them. Then came the question of who issues a license to him. So he had to issue a license to himself, saying, Mr. Harbanslal Sarin is hereby granted a license, signed by Harbanslal Sarin. So that is also in this little compilation you'll find. I bet none of you noticed the special thing, even though it's written there. So when I had Mr. Pratap Singh come to my office, he was chairman of the Bar Council at that time, and I showed him this. I said, this is Papa's license. And he says, Acha ji. Next day he went to the police station, reported his license is lost, and issued a fresh one to himself. He said, no, I've signed it myself. But, that's the lighter side of it. But Papa used to tell me, he says, Beta, there are only two types of lawyers in this world. Those who have all the work and those who have no work. So don't be in that category of no work. Work hard. There is enough scope in this profession to be successful. You can't be successful overnight. This is one profession which requires a few years of incubation. You have to survive from your own pocket before you can reach that stage. Once your work is recognized, first recognition comes from the bench. And that is in the shape of deciding cases in your favor. They're not doing you a favor, but they're deciding cases. And that's recognition of your industry, your hard work, and your intelligence. And the moment the message spreads, the clients determine your field of specialization. I was very keen on going into arbitration, but I ended up doing land acquisition cases because I won a few good cases, and next thing I had 1,000 RFAs from Batinda. And Mr. Grewal's father was one of the clients in land acquisition. But the relationships that you build, we'll never forget them. And long-term relationships, I can give you examples of this. Animesh's grandfather, K.N. Tiwari, was an advocate. I learned so much from him. His father, his grandfather, Mr. Vijay Tiwari, we lost him a few months ago. His uncle, Ajay Tiwari, was a judge of this honorable court, and he is their fourth generation, and we are still in touch. Because his father was a lawyer who brought out these journals, we continued, the Revenue Law Reporter and Law Times. His grandfather, the brother of Mr. Anand Mohan Suri, was my father's colleague. Again, a long-term relationship. Alka, you know. Mr. Anupinder Grewal's elder brother was my student in law, and his father was a client, and he was so blessed to have his father to live beyond 100 years. Very few have that privilege. And I am here thanks to my father and what he taught me. But let me not discourage the first generation lawyers. He was a first generation lawyer. He made a huge success of it. But even though I had the benefit and advantage of his advice at any time of the day, I also had the advantage of having briefs which he had got to argue them. But even very soon, you reach a stage that you are a first generation, because if you have to maintain your reputation, you have to show your skill. So no lawyer can last. There are enough examples of sons and daughters of successful lawyers who are unsuccessful as there are of successful sons and daughters who are successful. So it is ultimately your own effort. This profession requires industry. You can't say all your life that I'll get my work because of my father. No, Papa would have loved it, but I couldn't achieve it. So with those words, I would like to thank you, and I wish you all every success in the legal profession. One last thing before I forget. Papa used to always encourage youngsters. He would go out of his way. And he says, Beta, agar asi youngsters don't encourage kita, then what is the future of our court? So I'm open to it. Gurmeet has done such a fabulous job. She didn't have to, but comparing it, that's a start. But any one of you who's willing to or wanting to get some guidance, you're most welcome. Come and approach me. I find there's so much hesitation in youngsters in asking me. I'm not a Hawa, I am not untouchable. And I have free time. I have, for the last, ever since the lockdown, just before the lockdown, one last story. At the time of marking the list in the evening, Papa used to have all his 6, 7 juniors around him, and he'd be marking the cases, you go to this court, you go to this court. And every time, he'd tell us a story of what happened in a court, which practice I continued after 1993. When Nitin, my younger son, joined us in 2008, he came up to one day, he said, Dad, you tell us all these stories. Why don't you write them for the others to read about? So I said, I will. But a busy lawyer, I didn't find time. Then came the lockdown. And in that lockdown, I did find time. And my wife, the brilliant lady she is, she says, now's your time, write it down. So I have penned them down in the shape of a book. I said, it gives my experiences in a very general way, my father's experiences, the family's experiences. So if anything you want to look for about the book, about the accounts, about the register, they're all in here. It's a book which I have written, and the proceeds, if anybody wants to buy it, go to the Blood Bank Society, because I didn't want a penny out of it. And with these words, I'll say thank you and goodbye.
Thank you, sir. That was deeply insightful and very enriching.
Yeah, we can have
So
interactive session.
Now we'll have an interactive session. So if anybody wants to ask any questions to the panel here, please you can come forward with any question. Tanu ma'am, I think.
No, I wanted to, but I wanted to give.
Yes, youngsters a chance. Because Tanu gets a lot of chances in court. And when Tanu is speaking in the court, then others.
Then I'll speak.
Yes, others will get.
Then they will.
Young lawyers.
That's the way it goes in court also.
Maybe
If Tanu speaks, no one else speaks.
We have a young man here.
Or maybe they need me to break the ice first. I can go.
No, they will
There's
start
a
young.
man you have.
Yes.
Yes.
Sir, I also been a first generation lawyer. We try to prepare so much by the facts and everything. But whenever we are in the, at the dice, sometimes we don't even get the opportunity to speak. So that's our very basic problem when we face on the dice. Sometimes we are very prepared with law points, facts, legal knowledge. But sometimes the opposite counsel is very senior, and judges like just be quiet. They don't want us to hear. Then that's very.
No, they must be asking to be quiet. Let the other party finish, other counsel finish, then you can rebut. So then let him finish and then start. Don't speak in between. I don't think anybody will stop you.
Counsel, both counsels always get a chance to speak. The thing is that you have to make your mark. How do you make your mark in court is, if you are beginning, if you are starting your case, give a factual, date-wise list of dates to the judge. Say these are the facts. Come to your argument. Make it brief, make it concise. And then the judgments. What is actually happening in court is when you people come, you've prepared the case well, but in your over-enthusiasm, you will first of all hand over that Supreme Court judgment. That Supreme Court judgment is not going to help you unless the facts are applicable. So you have to go in a systematic manner. If you do that, every court will give you a hearing. I don't think there should ever be a problem on that issue.
Also, just I want to add one thing. To not be shot down by your opposite counsel or not be covered down is also part of an art of advocacy. Sometimes you have to learn that as well. Because if somebody is trying to shout you down, you can possibly make a point even then. So that is something you can pick up with experience.
So basically he has to put his point across. He has to, there's the advocacy car.
Yeah.
So how would you jump over him now?
Often it will happen that you will be awed by a senior counsel who is standing opposite you. But if you are well prepared, you will be able to answer. Because if you have merit in your matter and in your arguments.
The idea is to know the opportune time to address the judge. As I've said, don't try to interject. You will get a time. No judge will deny you an opportunity of hearing. But do it at the appropriate time and then answer it. I think you will. It's just.
And you don't need lung power for that. Just do it, otherwise you will hear.
Okay. Next, anybody else? Okay.
Not
Karan,
that
sir.
young, but I.
No, Karan,
So, in that write-up also which you shared about Mr. H.L. Sarin, you referred to meticulous communication with clients. These days we generally do that, we do not have time. And at times the client has to call, I do not know about it, but not many people, about 4 to 5 calls for a client to you to answer him that what exactly happened. I wanted to know what was his schedule, what time did he used to get up, what time did he used to study, what time did he used to sleep, and then also the fact that he was a very active social life also, he was part of Lions Club, which you also continued, we have been watching you over the years. What was the schedule? That also if you can share it.
He used to be back from his morning walk at 4:30.
Wow.
That answers it. But the thing is that the art of managing time is a totally different subject. We can have another talk on that. But weighing the balance between your court time working for the profession and family and social service, etc., has to be evenly balanced. You can do it. And do it in such a way that one is a refreshment from the other, and the other is, again, the profession is refreshing after that.
So, ma'am,
Now?
yes, please.
I have also a question.
Please,
Yes.
please.
Being a first generation lawyer, we don't have the privilege to take the matter. So I suppose I have an interest in criminal law, but someone refers me a matter from civil law. I can't say that go to that advocate because they do not accept that thing. So, sir, what is your opinion? Either we stick to one particular field or we should practice in diverse field also.
Well, today I'm sorry, I've just taken it on myself. Today there's such a field of specialization. If you have studied in a particular field, you'll find it difficult to accept a brief for something else. But in our time, and majority of the people who just end up with an LLB degree, they are generalists. It's the client who determine your field of specialization. Of course, your passion, your liking for a particular subject helps. But in the beginning, as they say, beggars can't be choosers. You have to accept every brief that comes to you, civil, criminal, anything.
Yes, everything.
And then if you are successful in one particular case, and that news also spreads like wildfire.
Can I add here? You master civil law, you'll be able to do and you will actually be able to practice in any field.
Correct.
You get your CPC right, you get your civil law right, you will get any brief in any subject, you'll be able to do it.
Correct.
So if you get a civil law brief, never refuse it.
Thanks.
Now we can have Tanu ma'am.
I can see the permission of everybody here. So it has been a wonderful session. I mean, no, it's been more than 2 decades I am here, but it also helped me a lot to learn something new, and I'm sure everybody has learned a lot. What I wanted to share with everybody and also put in the panel that it can be shared more with the youngsters. I personally believe that the lawyers are also said is an artist. He's just not a professional. And for somebody to be an artist, somebody has to be very, very innovative and creative. That innovation and creativity cannot come just by reading the statute, by the judgments, and by reading the newspapers and other things. I believe that a lawyer has to know more than the law subjects. He must know, I believe, must know the poetry part of it, some literature, some history, some science, some other things. So, sir, how do you think that lawyers should cultivate all these things in their daily schedule when they have to struggle, especially the first like to get a brief, then prepare it, then to present before the judge?
Go to Las Vegas. You learn everything in one go.
It's just a matter of time management, Tanvi. You just basically depends on your interests. So besides law, you have to develop other interests and have to find time for it. Be it exercise, be it meditation, be it anything, be it reading. We always find time to watch the reels on our phones. So instead of doing that, we do otherwise.
So that's why I wanted them to know that it's not just the reading of the files. This is how you reach there, you be successful, because you have to do many more
I have
things.
observed in court, lawyers are in court, either they are playing that Candy Crush or they are looking at reels, and sometimes the mute, that button goes off and I can also hear the reels. So hear what is happening in court, you will learn a lot, and in your spare time, do reading, do whatever you want, poetry, whatever interests you have.
Papa was always accused of never coming to the bar room. And I asked him when I was a young lawyer, I said, why don't you go to the bar room? He says, beta, this coffee, I don't drink it. So why should I go to the bar room? Whatever time I have, he'll find an empty courtroom, sit there and prepare his case. And he says, if you don't want to prepare a case, sit in a court and listen to some senior advocate arguing. You learn something. You learn how to argue. You learn how to present a case. You learn all these arts of poetry, etc. You know when to be stern with the judge, when to laugh with him, when to concede and give up everything. And once you do that, that is how you pick them up in the process of practicing law. But I think one very important point which was brought out was, and that's across the board for all, especially the young lawyers, don't ignore your physical health.
Absolutely.
Please follow regular sport or exercise. It is so important. I was talking to Dr. Rai, may his soul rest in peace. When I had just turned 40, I was 42, and I ended up with back trouble in the with him. He says, Sarin, our problem is nobody pays attention to sport. You are so busy making money, sitting on a table, you're in one position, you're putting on weight, and that's the problem. So with your back will give up, your neck will give up. So please follow this. And today in our country, it's showing up much more at the age of 60s and 70s because our hospitals are flooded with people because of lack of exercise.
Our inspiration is Justice Garewal. He finds his time for golf.
Yes.
He finds his time for exercise. He exercises every single day, which is, finding time from all this work is amazing.
We were together in the Advocate General Punjab's office in 95, 96. And he tried his level best to get me onto the golf course. I bought a golf set, I still have it, but I was there for 3 days, but I couldn't follow golf. I prefer jogging and other exercise.
Of course, I worked with them, and one very interesting instance. Mr. Sarin was for the claimant, the land acquisition matter. I don't know whether he remembers. It was in Justice Swatantra Kumar's court. I was the state counsel. I was opposing him in tooth and nail for enhancement of compensation. Then Mr. Sarin in lighter vein said, this argument coming from my learned friend who's also been a claimant himself. Then Justice Swatantra Kumar remarked, he said, thank God I don't own any land.
And sir, that's just getting
Remember,
a cue
sir?
from here.
Remember this?
I remember that.
So just getting a cue from here, I also believe that in the art of advocacy, having a very good sense of humor and wit is very important.
Absolutely.
And we need to cultivate it. It is not innate. All youngsters have to read something, think about it, practice with a friend, because whenever the arguments are very, very heated up in a court, and also you need to de-stress the ambience. The wit not only diffuses the tension, it also ends up most of the time getting the relief from the judge when you have made the judge laugh.
And lawyers should be smiling. Don't be too serious.
Yes.
Sometimes it happens, we are issued notice, granted stay also, still that grim face. At least smile. Yeah, that's very important.
The judge also needs some appreciation.
You have a question?
But my question is, as the minors advise, we have to encourage the opportunity to argue minors. But as there is, we have the few and very few opportunity to argue the matters. At the time of how can I take get out this is the matter, we have to take a chance.
Alright, I'll tell you. You come to the court for an adjournment. The judge has read the file. Judge has made up their mind that, alright, I've read the file, I know notice of motion is to be issued. What are we looking at is you stand there and ask for an adjournment. So 2 questions are put to you, you're not able to answer. That's it. If you are prepared, if you've got the file, you asked your seniors asked you to get an adjournment, you give those facts, give that answer, notice motion will be issued.
Sometimes maybe failure, there is the fear to failure, my lord. They give 2 chances to me and my senior give me 2 chances.
I'll tell you, when you are asking for an adjournment and as a judge, somebody is encouraging you to speak up, they will never dismiss it on your head.
Last
They will
resort,
never
tell them
dismiss
it's your first case.
They'll never dismiss it.
Just to add, even if you're asking for an adjournment, if you're still prepared about the matter, you might still get relief, because if you're asking for an adjournment and a question pops up and you're able to answer it, you might still get relief. So be prepared even if you're asking for an adjournment.
Yes, you will.
You can sit and answer.
Sir, I'm being more
Okay.
questions.
There's not a courtroom anyway.
Sir, the challenge we face that we have, written laws, and that's what we have studied. But when we enter in the courtroom, we make our argument, and we don't get that relief that the law should be. How to get the law enforced? What is written in the law? I mean, this is the challenge I'm facing of my-
Law is always applicable to the facts of the case. So when you're looking, see, what happens is you randomly look up the law and say, all right, this is the proposition of law. No.
Yes.
Proposition of law also has to be based on the facts. It has to apply to the facts of the case. There may be a distinction in the facts. If there is a distinction in the facts, then that law will probably not help you. So if you have to bring it within the 4 corners of that judgment, what I used to do as a lawyer was that when a case would come to me, I would read it, I would read the record, which is again very essential. Like in an RSA, you read the record. You prepare your case in your mind, and then you find the judgments. bring your arguments, bring your grounds within the four corners of that judgment, and then draft your grounds. You will always have a case. You will always have a good case.
And one more tip. I was taken to meet Justice I.D. Dua, Judge of the Supreme Court, when I just joined the profession. And he told me this, and it has proved to be to the hilt. He says, you have to know the facts of the case. Know them so well, better than your client. Present the facts. If you don't know the law, the judge will fill up the gap, because he's going to apply to the facts of the case so that he does justice. So don't worry about the law. Worry about the facts. Highlight the injustice which is being caused to the client, and you should get the relief.
फर्स्ट जनरेशन लॉयर तो मैं ना पढ़ के जाती हूँ जजमेंट में रेलिवेंट पॉइंट लेके जाती हूँ जब वो इन्फोर्स नहीं होता ना देन आई गेट डिसअपॉइंटेड सो आई जस्ट वांटेड टू नो हाउ टू
Not get disappointed.
No, that is what you just said, that focus on the facts of the case and not on the law.
Yes, not on the law. Law will take care of itself.
The facts are important and relevant. So, on that note, I think we can wrap up. Yeah, okay, please.
As a first generation lawyer, what all things we should focus on definitely, and what all things we should not indulge in during the court?
No, and focus on, of course, you have to work hard, everybody has told you that. And you got a lot of spare time, utilize that. And if you are working with a senior, make yourself indispensable. If you are getting the facts, giving him a note, relevant law, everything, no senior would like to leave you, he will keep promoting you. So that is initially you got a lot of spare time. You have to manage your time and upgrade your skills. Two aspects need to be upgraded. One, the knowledge of law and your expression. The way you can put across, that is very important. You have to work on your expression and law. These are the two things you can learn at any age.
Thank you.
Due to paucity of time, I think we can wrap it up. We now have my younger colleague Gursheh who will give the vote of thanks.
Before starting with the vote of thanks, because there were 2-3 questions on that factor, I want to share a personal experience as well. I'm working with Dr. Sidhu, and I was petrified of arguing RSIs in civil cases. And I always used to be happy when the number was far that it won't reach. And then, so once the opportunity came, it was an old RSA when they started coming in the urgent list. So sir said, no, you have to only argue, I'm not going to go there. And at that point, it was on a very typical proposition of primogeniture. I had never read about it, and it was before my lords only. And I took that opportunity of arguing, even though it was a high stakes matter and there was a lot of fear of failure, like my brother said. But luckily I got that relief, and happily or sad, but now all the old RSAs in my office. But now I'm more confident, because once I got that relief, I am confident that this is how to proceed.
That's how it goes.
Yes.
That's how you get encouragement.
Just wanted to share, because
This was an LR application, and the issue was primogeniture. He just brought out, he gave me the facts, and I allowed that application immediately.
Yeah.
And that's where, that's what I was saying, that you give those few facts that the judge is asking. We know the law, we'll give you the relief.
That application was pending since 8 years, which is not allowed that day.
This reminds me of a case which involved these Jakiritas of Manoli, and a huge stakes case. And my father, Papaji, was busy in court number 10, and I ran to court 4, this D.K. Mahajan's division bench, and I started arguing. 5 minutes later, the clients brought my father there, and he got up, he said, "My lord, may I take over?" And Justice D.K. Mahajan said, he was so blunt, "Sit down, Mr. Sarin. Your son is doing much better than you." I was embarrassed, but that night I heard him narrating the story to our neighbor, Rai Bahadur Harprasad, with all pride in his chest. My son was doing better than me, sir.
So with that, I think we should wrap up. It was truly so insightful to learn about one of the doyens of our bar, Mr. H.L. Sarin, and to learn the art of advocacy from a distinguished panel, all of whom are connected with St. John's also in one of the ways, so I'm very happy with that as well. We would like to thank also the Chief Justice and the judges for allowing us to use the Le Corbusier Hall, and to allow for academic discourse, and the Indian Law Institute and the Bar Council, who have allowed us to have this atmosphere. We're having discussions every week, and even in the bar room, the discussions are going on. So we want to cultivate an atmosphere of academic discourse and discussion and growth. We would like to thank our panelist, Mr. Animesh Sharma, for his insights, and our members from the bench, Honorable Mr. Justice Vikas Surya, Honorable Mr. Justice Alka Sarin, and Honorable Mr. Justice Anupinder Singh Garewal. And Sarin said it's always a delight to hear him all the way from Sajoba, and would like to thank him and the Sarin family for upholding the legacy and contributing to the bar like the way Mr. H.L. Sarin used to do. So, and thank to all of you. This is the most turnout we have in any one of the lectures. So it is like big thanks. So that atmosphere is getting cultivated. Thank you all. Thank you for being here.